Assalamualaikum warahmatullahi wabarakatuh. My name is Nabilah Binti Zolkarnain. Matric number 11931338 from group KME3. Lecturer name Dr. Syed Muhammad Najib bin Syed Omar from Islamic University Science of Malaysia. For this slide is about the case review for the Sunrise Berhad and Anor vs LNM Agency Sundaran Berhad 1999 3 MLJ 544. Case review under the sale of goods. For the case Sunrise Berhad and Anor vs LNM Agency Sundaran Berhad 1999 3 MLJ 544. For the plaintiff 1 and 2 is Sunrise Berhad and Anor. For the defendant is LNM Agency Sundaran Berhad. For the summarize of this case review is about the first plaintiff is the developer and the responsible for the project condominium, and the second plaintiff is a related company. The first and the second plaintiff have collaborate to develop mixed condominium and the commercial development. The second plaintiff was the main contractor for the development of the condominium. And also the second plaintiff said that he had received two new tower cranes from the defendants made in Chinese and under license from the French Portain company. But the two new tower cranes always damaged and could not function for a long period. And this has caused the both of plaintiff losers and the delay for the project. And the defendant claimed that two tower crane is a new. For the issue have three persons, which is the first plaintiff, the second plaintiff, and the defendant. For the first plaintiff is a developer and responsible for the project, and known as the Monkera Pine project, while the second plaintiff is a person that related to the company as well as the main contractor. The second plaintiff had received two new tower cranes from the defendants. The transaction involved two tower cranes from the defendant to the sale agreement on 12 February 1991 and the maintenance agreement on 31 May 1991. There have been many sale discussions that have discussed in the agreement. The tower cranes manufactured in China under a license from the French Portain company and was known by Yangnong Portain Top Kit. For the tower cranes broke in a piece and installed at the plaintiff first project site in July 1991 and approval from the Department of Factory and Machinery. The purchase price for the two tower cranes of 1,378,000 paid by the second plaintiff, and the tower cranes commissioned at the work site on 15 May 1991 and placed in the Scott and Everett tower blocks. For the summarize of the court decision, the action has dismissed. Number one is the defendant is not aware of the case. The only appeal against the negligence in the pleading that have been made is from the second plaintiff only, namely negligence or breach of the agreement by the defendants. The first plaintiff submission rely solely on a breach of duty, but nothing pleaded against the defendant. On this basis, the first plaintiff claim were unsuccessful. And number two is the claim made by the first plaintiff is a failure. There is no evidence to suggest that the suffered economic losses, and there is no evidence that can be taken from the second plaintiff about the delay of the project. So the court cannot take that into the account, and the first plaintiff claim against the defendant was dismissed. Number three is in the Sale of Goods Act 1957. It is said that the goods sold must be suitable for the intended purpose. The court had received witness testimony from the plaintiff during the discussion that they have informed the defendants to use for the condominium construction. And number 4 is discussion have been made for the pre-sale and pamphlet from the defendants. The sale of the claim has a trading name and has described in the contract. Number 5 is the second plaintiff is satisfied and convinced that the defendant has bought the correct goods. Since the plaintiff is already familiar with Chinese-made French portine planes, so the plaintiff should assume that the tower crane have a similar merchantable quality. And the last one is the second plaintiff that also did not give sufficient evidence to the court. The court relating that for the delay of the project by the defendant and the payment of to the subcontract and the payment for the subcontract MIBA company. With this, the court considered the case of the second plaintiff also was dismissed.